Hi, everybody. I'm Jeff Weiss, co-chair of Steptoe's International Trade Policy Practice and lead of the firm's supply chain team. Welcome to Supply Chain University, where we dive into the legal, policy, and advocacy issues involving supply chains. To find out more, please visit our website at steptoe.com. On this episode, we're talking about ITC exclusion orders and their impact on supply chains. Our guest today is Matt Bathen, a partner in our Washington, D.C. office. Matt focuses his practice on litigating Section 337 cases at the U.S. International Trade Commission and also representing clients before U.S. Customs and Border Protection. And he's also a former senior investigative attorney at the ITC's Office of Unfair Import Investigations. So Matt, thanks so much for joining us, and we're really excited to have you here on the program.
Thanks very much, Jeff. It's a pleasure.
So maybe we could start off with the basics and just talk about the International Trade Commission and its role and the potential supply chain impacts.
Of course. So the ITC is a federal agency tasked with addressing unfair trade practices related to products that are imported into the United States. Allegations of unfair trade practices would include patent infringement, but it also handles other things such as trademark and trade dress infringement, copyright infringement, or trade secret misappropriation. ITC investigations are known as Section 337 investigations based on the governing statute of the ITC. They're typically around 50 or so ITC investigations each year. The products at issue vary. They include computer and telecommunications technology, consumer products, electronics, automotive. There's really a wide variety of products at issue, and they can have a significant impact on large portions of the economy in view of the sweeping remedies that are available through the ITC.
And can you run through how ITC investigations are conducted?
Sure. An investigation begins when someone files a complaint alleging a violation of Section 337. And the commission reviews the complaint and decides whether or not it will institute an investigation. If it does institute an investigation, it assigns it to one of the 6 administrative law judges at the ITC. And the ALJ will hold a hearing and issue a decision. And that the ALJ's decision is then reviewed by the full commission, and the full commission will issue a remedy if it finds that a violation has occurred. The important thing to note here is how fast the ITC operates. The ALJ hearing will probably take place 9 to 10 months after the investigation starts. And the ITC's final decision, including the remedy, will issue 16 to 18 months after the investigation starts. So it's very, very fast.
And if the ITC finds that there are unfair trade practices taking place, what happens next?
So the ITC can't issue money damages. What it does issue is what's called an exclusion order, and that is a form of prospective relief. And an ITC exclusion order forbids the importation into the U.S., sale for importation into the U.S., or sale after importation in the U.S. of any products that are found to have been in violation of Section 337. So an ITC exclusion order directs customs to stop those products at the border. And the order takes effect as soon as the ITC issues it. An importer can continue to import for 60 days after the order issues, subject to a bond requirement.
Wow, so it's clear that these orders can have a pretty dramatic effect on your supply chain, and you might not even know about it until your product or products from your supplier are stopped at the border. What are the practical effects of an ITC exclusion order?
You're absolutely right, Jeff. The exclusion orders issued by the ITC come in 2 different flavors. There are the limited exclusion orders, or LEOs, and general exclusion orders, or GEOs. Limited exclusion orders are more common, and they are limited to the party specifically named in an ITC investigation. And such an order would instruct customs to prevent that party from importing into the U.S. the products that have found to be in violation. But now, as a practical matter, an LEO might actually, the scope of an LEO could be broader than it seems. because
Hmm.
LEOs not only stop the named party from importing the products, but it also anyone by or on behalf of that party. And they also apply to affiliates, parents, subsidiaries, and related business entities. So the scope is not quite as limited as it might seem at first glance.
Right.
Now, obviously, if you're a named party and an exclusion order enters against you, it will have a direct impact on you.
Mm-hmm.
But even if you're not a named party and exclusion order issues, it can still have a dramatic impact on you and your supply chain. So, for example, the LEO only impacts a named party, but it can impact downstream purchasers because it will affect your ability to obtain imported components, for example. And if your supplier is involved in an ITC case and you import products from that supplier or the supplier imports them for you, then when the exclusion order begins, that won't be possible any longer.
Right.
Moreover, selling products outside the US, if you know that they're going to come into the US, is potentially a violation of an LEO, which can result in substantial penalties. So if an LEO issues, you can find yourself, your supply chain really has been dramatically impacted, even if you yourself are not in the case and didn't even know anything about it.
Right. No, that's super interesting and important to understand. You also mentioned that the ITC can issue general exclusion orders, and how are those different from the LEOs you were just talking about?
Sure. So general exclusion orders, or the GEO, is even more broad and more powerful than an LEO because it's not limited to the parties named in investigation. It would apply to anyone's products that are determined to be in violation. So it's effectively an injunction against the world, and it can potentially be a huge disruption to your supply chain. For an LEO, you may have alternative suppliers that if one is no longer available to you because they were named in an LEO, you would have other options in terms of obtaining products that you need to import. But with the GEO, it's quite possible that all suppliers are going to be kept out of the US. So you won't have any options to replace that imported component, or you'll be very limited in what you can replace it with. Now, GEOs are tough to obtain, and rightly so because of their broad scope.
Right.
So a complainant who wants to get a GEO must not only show a violation of Section 337, but it must also show that it's necessary because there's a likelihood of circumvention of just an LEO, and that there's a widespread violation of Section 337, and that it's tough to tell the true identity of the infringing products. Mm-hmm. Another thing to note, that GEOs can be issued in cases where few or even none of the named respondents actually show up to dispute the allegations. And if no respondent appears, it's more likely that a complainant will be able to prove a violation. And moreover, the timeline can accelerate because it won't take as long as necessary if it's not a contested case. So it could be a year or less.
So it's clear that those orders can have disruptive effects on supply chains, both direct and indirect. So what would you advise companies to do to minimize the risk to their supply chain based on ITC exclusion orders?
You're right. The risks to you can be swift and potentially very severe. But there are some things you can do to minimize that risk or try to avoid it as much as possible. Particularly, you want to know about these things in advance. If you have to switch suppliers or come up with a new design, perhaps, the longer you have to put that plan into effect, obviously, is going to make things better for you. So, as I mentioned, there are roughly 50 ITC complaints filed at the ITC each year. So you can monitor those complaints. They're public, they're accessible through the ITC's website, and it's relatively straightforward, right? Look to see, look at the complaints, look to see who's named. Are any of your suppliers named? Parties that you care about? What's the technology at issue? Is this a technology that's relevant to your business? Or is anything like that? So you want to pay particular attention, obviously, to cases where your supplier is named, so that you can begin to assess the potential impact to your business. With respect to GEOs, a request for a GEO typically must be included with the complaint. So you may want to look for that. If there's relevant technology, even if one of your suppliers isn't named in that complaint,
right,
but it's relevant to your company, to your business, you may want to take note of that and try to monitor it more closely. If your supplier is named in an ITC complaint, evaluate the importance. If you lost the ability to import products from that supplier, are there alternatives? How long would it take to switch to a new supplier? Is there perhaps a domestic supplier, which would obviously take you outside of ITC jurisdiction because all it focuses on is the importation of products? In the event that all of your suppliers are at risk or there aren't alternative suppliers you could turn to, can consider whether or not a design around is possible, or if you can somehow deal with this issue of not being able to obtain a component or other piece that you've been importing and that you need. When your supplier is involved in an ITC case, ask them to provide their assessment. What's the risk? You may want to help them, assist them with defense if this is a critical component, a critical supplier for you. And as we mentioned earlier too, not all respondents show up. So you should pay particular attention to investigations that are of interest, of note to your company, where named parties don't show up or are unlikely to mount a strong defense, because obviously the likelihood of an exclusion order issuing is probably going to increase in such a situation. As far as practical matters you can do, evaluate your purchase orders and supply agreements with your suppliers. Perhaps you want to include a notification requirement that if a supplier is named in an ITC case, you want prompt notification. Again, to give you the time, the benefit of time to deal with those issues should they arise. And lastly, I'd note that the ITC considers public interest issues before it can enter into a remedy, and it invites public comment in a number of different times throughout the investigation. So if there's a case that you're monitoring and you believe it impacts your business, there are chances for you as a member of the public, even if you're not a party, to provide comments to the ITC that they will review and may take into account when they craft the remedy and the scope and timing of the exclusion order.
Well, thanks so much, Matt. That was incredibly clear, the potential impacts that exclusion orders can have on supply chains. I also thought you laid out very clearly the things that companies should be doing to monitor what's happening at the ITC and what's happening with their supply chains, and also what questions they can ask and what steps they can take to mitigate. And clearly, as you said, the earlier you can find out what's going on, the better off you're going to be. So really appreciate your coming on and providing these insights on the interaction between exclusion orders and supply chains. It really is all supply chains these days. I suspect we'll be talking again on the program. So really appreciate this. This was great.
Yeah, thank you, Jeff. Pleasure was mine.
And that's it for this edition of Supply Chain University. You can find this in all of our videos at steptoe.com. You can also find us on YouTube, where you can like and subscribe. Thanks everyone for joining us, and we'll see you next time.